Okay, great. We welcome everybody to today's press conference on the legal access for separated and reunited families, or the Miss L settlement. We're going to head and get started in 1 minute. All right, we're at the 1 minute mark. Welcome, everybody. My name is Bilal Asghariar. I'm the Director of Communications at the Acacia Center for Justice. We're here today because last week the Trump administration put the same families that subjected to its inhumane family separation policy during its first term in its crosshairs once again. The Acacia Center for Justice received a notice from the government stating that they plan to discontinue the Legal Access Services for Reunited Families program, or the LASRF program that Acacia operates, which provides legal information and advice to class members and qualifying family members of the Miss L settlement, the same families who were subject to the first Trump administration's cruel family separation policies. We have an illustrious list of speakers today, so I will keep my remarks short, but I just want to say um, I'm I'm sadly not surprised that we're here. I thought that, but I still thought that family separation and the stain on our nation's history and the shock to our conscience that it was would speak for itself, and that the administration would understand that it was a bridge too far. I thought that family separation was, in the history books of Native American children being taken away from their parents, or the children of enslaved Africans being taken away from their parents. But unfortunately, here it is in the 21st century once again, and the administration is saying that doesn't have any remorse anymore about this. And so today we're going to be speaking out against that and hearing from our experts in kind of a chronological timeline of this family separation crisis, how it started under the first Trump administration and where we are now. Um, our first speaker today is Michelle Brenet, the executive director of Together and Free, and she's also the former ombudsman for immigration detention at the Department of Homeland Security and served on the Family Reunification Task Force. So we're really privileged to hear from her today. Michelle, please take it away.
Thank you so much, Bilal. And thank you, everybody, for joining us today. I'm going to keep my remarks brief because I want to make sure that you all have time for questions and to hear from our other speakers. But as Bilal mentioned, I was under the former administration, under the Biden administration. I served as the executive director of the Family Reunification Task Force for 3 years. The task force was created in response really to the public outcry over what the consequences of zero tolerance policy were, which was to tear apart families, separate them, and really not even keep track of them or provide any mechanisms for those families once they were separated. The task force did a lot of work in helping to identify who was separated and work towards implementing both the President Biden's executive order, but also the provisions of the settlement agreement in Ms. Al that was reached in December of 2024. So that included identifying, helping, creating a system for people to actually become members of the class, to register themselves, and obtain the services that were provided under the settlement. Very critically among that were legal support services. And the government recognized at the time of the settlement that the families, in order to be able to access all of the other provisions of the settlement, would really require support through attorneys and legal services. The settlement commits to support just short of actual direct representation, and that makes things in many ways complicated, right? Because there's so many pieces of what is involved in providing these families with what is real access to what they're entitled to. And I just want to note that, during the task force's existence, almost 800 families were reunified under that process. Many others were reunified separately or prior to the task force's existence, and many have continued to reunify. But there are many, many who have not yet entered the process and who have not had a real meaningful opportunity to obtain relief and the ability to be together and feel safe in the current environment, especially. And so, again, just really emphasizing how critical these legal services are and how much these families need them. You'll hear more examples of this, but the families really are. The process is complicated. I think all of you on this call probably already know that immigration is complicated, and understanding what they already have, what their current situation is, what they're entitled to, and how to get it really requires professional guidance. So I'll stop at that.
Thank you so much, Michelle, for that perspective. We're going to turn next to Zain Lakhani, Director of Migrant Rights and Justice at the Women's Refugee Commission.
Thanks, Bilal. And I'll just begin by saying it's a real sort of honor and a pleasure to follow in the footsteps of my predecessor, Michelle Bernay, both in this call and in this work. So with my time, and I'll also try to keep things really brief, I just want to kind of take a step back and kind of go back to the moment in the immediate aftermath of family separation, because I think that one of the things that we are really seeing hidden behind a lot of this abstract language, right? Behind a lot of, termination of programs or sort of rescission of services is the fact that this is family separation by another name, and that there are real human costs and real human faces behind these experiences. And for a lot of the families who are facing real catastrophic harms, renewed separation, and other dangers as a result of the termination of these services or termination of this program, what happened during family separation, it's not the past, right? It is the present. It is still the present for a lot of them. And so I wanted to just take a few minutes to share some of the words that they have shared in their own words. During family separation, Michelle and her team traveled to detention facilities. They spoke directly to migrants and to children about the pain and the anguish that they were feeling. And in the immediate aftermath in 2020, WRC launched an oral history project with Barnard to be able to, sort of document some of these stories, an oral history project to speak directly to parents and children about some of what they had experienced. And I just want to take a minute to kind of share a little bit of those experiences today. So the folks that we talked to, the parents and the children, a lot of them are differently situated. Some of them had been reunited, and those people were recalling the ongoing pain and trauma. Like one 15-year-old boy from Guatemala who was separated from his mother for almost a year, who shared, "Those 9 months were torture for me. Really, I didn't know anything anymore. I just felt like I wanted to kill myself. That's what was going on inside of me, to kill myself and not know anything anymore. It changed my life. That time I was so sad, so depressed. I didn't want to know anything. All I wanted to know was where my mother was, to see her, to hug her, to know she was okay, because I was so worried about her. I didn't know what was happening. I didn't know if she was all right, even if she was alive, or what was going on. I was just so sad." Others that we spoke to described the trauma that still lives inside of them, inside of their bodies. One mother described her terrible anxiety about losing her children, even though they had been reunited. So she said, "I live with this terrible insecurity because I still experience it every day. When I go to work, I check to see if my children are still there. At night, I wake up and I always go to check on my children because it feels like they are not with me. It's an insecurity that has remained so long after." But perhaps in this moment, so vital to this particular moment, are the stories of parents who were not yet reunified with their children at the time of the interview. Parents who spoke of the inconceivable anguish and fear about not knowing where their children are years after being separated. And what makes their words so particularly vital, I think, for this moment is, as we said earlier, that for many of these families, this is an ongoing situation, right? This is not the past. This is their present. And many of the other speakers on this call are kind of going to carry the experiences of families up until the present day, and really to kind of talk about what families are experiencing on an ongoing basis. But I think just having sort of their words in this moment of what it felt like to still years later be apart from their children is just puts the real human face and real human toll of what this administration is doing, cutting migrants off from the support services they so urgently need. And this is not the only way in which we're seeing that happen, right? We're seeing all kinds of legal access and just even basic know your rights information and attempt to kind of, hive migrants off from that completely. And I think that it's so insidious because you don't actually see the way it impacts real people in quite the same way. And I don't think that's an accident. So I just want to end with the words of a mother from Guatemala, who at the time we spoke to her was still desperately seeking reunification with her child. And she said, "I have this pain that lives inside my heart. It's so hard to talk about this situation with anyone because years have passed and I feel the pain as if it were yesterday. It's so burned into your mind and then in your heart. It's something that can never fill the void inside of you." Thank you.
Thank you for sharing those haunting words that really remind us what we're talking about. Our next speaker is from the Young Center, Kelly Albinek Cribbs, whose last name only has one B. I'm sorry for the typo.
No worries at all. Good afternoon, everyone. Thank you so much for being here today. I'm Kelly Cribbs. As Bilal said, I'm an attorney with the Young Center for Immigrant Children's Rights. And we're here today to shine a light on the Trump administration as it stands poised to breach the settlement agreement it entered into with immigrant families it cruelly separated back in 2017 and 2018. And I'm going to kind of continue in the same thread as Zane started so beautifully, and inhumanizing this conflict, which could easily be cast aside as yet another lawsuit unfolding right now. And I want to make sure we don't lose track of the children and families at the center of this. At the time of family separation, I was serving as a federally appointed child advocate for children in immigration detention, and I worked with a number of separated children. And I want to tell you about the day I met an 11-year-old boy from Honduras that I'm going to call Danilo. He had curly brown hair and hazel eyes, and all he wanted was to be able to talk to his dad, Hernan. It had been 3 months since they were separated, and in that time, Danilo hadn't seen his dad's face, hadn't heard his voice, didn't know where he was. When they finally had their first video call, the tears flowed from father and son alike. And when they were finally reunified after 4 months of separation, they hugged for so long, it was like neither of them ever wanted to let go. My own son is now almost the age that Danilo was when he was separated from his father. And it is all too easy for me to put myself in Hernan's shoes, to imagine the anguish of the moment of separation, the terror of the ensuing uncertainty, and the regret for ever having tried to seek safety in this country. It's now been 7 years since Danilo and Hernan were separated. I'm still in touch with them on a regular basis. Only Danilo has been able to access a lawyer to help him file for asylum. His case is still pending. Hernan hasn't been able to access legal assistance. He's still waiting for that, and he's still waiting for the chance to seek the right to remain here with his son, to remain safe from the danger they fled in Honduras. But this threat of deportation looms large over both of them right now more than ever. And the very real possibility that they could face another separation is so close to home for them. How can we expect these families to heal under these circumstances? Hernan once told me that he felt marcado. He felt marked by this experience forever. And to be sure, Hernan is not defined solely by the trauma he endured. His family, like so many others we've worked with, is strong, vibrant, loving, and full of joy, despite all the grief we've inflicted on them. But this government owes it to them, yes, legally, but also morally, to fulfill its obligations under the settlement. Hernan is entitled to these legal services. They are the gateway, as Michelle laid out, to so many other benefits under the settlement. And without a lawyer to guide him through the legal pathways the settlement created, Hernan will effectively be denied a meaningful opportunity to win the right to stay here and to stay with Danilo. And this family is one of thousands that need and are entitled to these legal services. So in closing, I'll just say that we at the Young Center are hopeful the court will stand with separated families and ensure that they can continue to access these critical legal services that they are owed. Thank you.
Thank you so much, Kelly. We're now going to hear from Danielle Fritz, Directing Attorney at the Immigration Center for Women and Children.
Thanks, everyone. Yes, my name is Danielle Fritz. I'm a Directing Attorney at the Immigration Center for Women and Children, or ICWIC, as we call ourselves, based in our San Francisco downtown office. And ICWIC is one of the legal service providers implementing the LASRF program. And when we launched services, we quickly realized that there are so many unrepresented class members and qualifying additional family members eager to receive legal advice and assistance. And most did not understand what options they have under the Mizell v. ICE settlement agreement or how to go about pursuing relief. In the past year, so we're still in the first year of service provision, we helped 57 people successfully file their re-parole and work permit applications. We placed multiple children with pro bono attorneys for full scope representation. And we're providing ongoing services to multiple class members who wish to pursue asylum under the special procedures outlined in the settlement agreement. But many families have been waiting for months for services already because the legal service providers like ICWIC never had the capacity to meet the demand. And terminating the program now means that those families who've been waiting for services may never receive them. And there are so many barriers facing people who try to file motions with immigration court or applications to United States Citizen Immigration Services alone. I could go on forever about that. Many class members without this assistance, they're going to miss their deadlines outlined in the settlement agreement, including their deadlines to file for asylum. Parole and work authorization will lapse for hundreds of individuals. Yeah, and I'll end with an anonymized quote from a class member's separated parent, which I'm sharing with her consent. I tried entering the United States with 2 of my children. After crossing the border, I surrendered myself to immigration officials, and right away I was separated from my children without an explanation. I was taken somewhere else and interviewed, and the officer told me that I was not going to be reunited with my children. I couldn't make sense of what was happening because it was all so fast and inhumane. I asked myself, who would do this to a mother and her children? The officer asked why I left my country, and I gave my reasons, but he told me it was a story he had heard before. He was dismissive of my distress, and he told me that the laws had changed and the United States government was now allowed to separate me from my children. I felt like my world was falling apart. And these children, so the mother here, she was removed to her country of origin. The children were placed in Office of Refugee Resettlement custody and released to their biological father, who sexually abused the daughter and physically abused the son. They're all reunited now, and this is one of the cases we were able to make a successful pro bono placement for, and the kids will be pursuing relief, special immigrant juvenile status. So I'll end there. Thank you.
Thank you, Danielle. And before we hear from our last speaker, I just want to remind everyone who's joining us today that we welcome questions from members of the press. When you would like to ask a question, you can use the question and answer function or raise your hand. Just do identify yourself and what outlet you're with. Okay, we're going to hear now from Sarah Van Hofwagen, Managing Director of Legal Access Programs at the Acacia Center for Justice.
Thanks, Bilal. Thank you, everybody, for being here. As Bilal said, I'm the Managing Director of Legal Access Programs here at Acacia. I use she, her pronouns, and part of my role has been to oversee the LASRF program, the Legal Access Services for Reunified Families program, and to work closely with our providers on the ground. So thank you all for being here. So over the last year, Acacia has worked with 9 regional legal service providers and 1 national pro bono partner to provide a legal lifeline to the families who were cruelly separated from each other under the first Trump administration. And you've heard those stories today. This program has provided critical legal services to more than 1,000 formerly separated children, parents, and their qualified additional family members who reside in 37 states, plus the District of Columbia. And I want to be really clear today that legal access services for these families is mandated by the Missile Settlement Agreement, which the government agreed to and which is binding upon them. And as a result of the Missile Settlement Agreement, the government contracted with Acacia, and then we contracted with other groups to create this program. Through the program, formerly separated parents and children receive individual consultations about their immigration situations, assistance applying for parole and work authorization that they are entitled to under the settlement agreement, hearing preparation, and help seeking lawful pathways like asylum or like special immigrant juvenile status that you just heard about to remain in the United States. And really, this program, we've heard again and again, has been invaluable for the class members who've been able to receive services. The network of immigration experts like Danielle and her team have provided them with tailored, trauma-informed advice and assistance. And over the last year, the LASRF network has provided Missile class members and their qualifying additional family members with almost 1,500 individual consultations, given parole advice and assistance to nearly 1,000 individuals, and provided employment authorization, information, and support to more than 800 people. But as you've already heard today, the demand for services has been enormous, and providers have been forced to schedule appointments months in advance and prioritize urgent deadlines. Since the rollout of the program, only about 12% of the individuals that are on the class member list that we receive from the Executive Office of Immigration Review have received services. And this leaves approximately 8,000 people, class members and their qualifying family members, without legal access or support. And as you've heard, on April 11, the government informed Acacia that they were not renewing this program and that all services provided by our national network would end on April 30th, in less than a week. The government has provided no transition or wind down plan for us, and it's left the legal service providers the impossible responsibility of calling families and telling them that they are not going to be receiving the legal support that was promised to them. As a result, these families who've endured so much trauma at the hand of our government have been told that the United States is not keeping our promise to help them rebuild their lives or assist them with their cases. They will now be forced to complete complex immigration applications without assistance, applications that have to be completed in English. They have to explain the trauma that they've endured and how that meets the standard of proof for asylum, parole, or another form of relief. This is really an impossible task without legal assistance. And to make matters worse, this is happening at the same time that the government is eliminating legal services for immigrants across the board, leaving Missile class members even more vulnerable and with nowhere else to turn for help. As I'm sure most of you know, the Immigration Court Help Desk and the legal orientation programs for custodians are just two of the legal orientation programs that have been shut down. And the government ended funding for representation of unaccompanied children, including the children who became unaccompanied when the government removed them from their parents. And now more and more children are being forced to attend court alone. Meanwhile, the United States is targeting vulnerable immigrants for detention, deportation, and other enforcement actions. Detention facilities are over capacity and conditions are rapidly deteriorating. The risks for class members are skyrocketing, and the elimination of services means the further erosion of due process. As Danielle mentioned, because of the decision to end this program, parents, children, and their qualifying family members will miss deadlines to apply for parole and employment authorization. Their status will lapse, they will lose the jobs they depend on to survive, and be even more vulnerable to detention or removal from the United States. They will be forced to go to court alone, and in the months to come, miss their deadlines to apply for asylum and other forms of relief. And really, by cutting off a promised legal lifeline, the United States is breaking our commitment to the families we already subjected to so much harm, ripping away promised help. It is a new betrayal, exacerbating the trauma already inflicted on these families and ensuring that the legacy of family separation remains. Thank you.
Thank you so much, Sarah. I just want to make sure people on the call understand. So you said this program has only served 12% of the class members the list that you received. That means 88% of people who were separated and fit in this class have not received any services.
88% of people who are on the class member list, so class members and qualifying additional family members, which is a term of art that includes some close family members who maybe weren't separated but related to people, have not received services through this program. Maybe some of them have found private counsel, but we know that very few people are able to afford and access private counsel. We know now that they're not getting assistance through the Immigration Court Help Desk or another program that existed to provide services because the government has also eliminated those programs. If the kids had an attorney through the Children's Representation Program, that child is losing their attorney right now. So yes, people are losing they have not been served, and those that have been served are losing the services that they were able to receive.
It's staggering. As a reminder, members of the press, you're welcome to ask a question now. I did want to follow up and say, is this something that the government can provide in-house? What is their plan? You said there's no plan. They've offered no plan for continuation, but what's going to happen next to these families?
Yeah, so we have received zero information about what a transition plan might be and what the government's plan is for services. They've just told Acacia and ICWIC and our partners that our services are stopping on April 30th. As you heard, we have people lined up to receive services. We have people with urgent deadlines who we've been in the process of helping them apply for parole or special immigrant juvenile status or get ready for a hearing. And those people will not get those services. We don't know what the government intends to do in the program outright. I think you asked, could they just run the services themselves internally? I don't see how that would comply with the terms of the settlement agreement. They have to provide legal advice and information, and the government, which is the perpetrator of the harm, also the adjudicator of whether or not somebody can stay in the United States, can't ethically or reasonably be in the position of then giving somebody confidential legal advice. I think the issue of trust with the government will be extremely difficult for class members who were ripped from their families by the government, and now they are being asked to share all of the details of your trauma and your situation and like the questions you have with a government officer. I don't think people would show up for services or receive services even if they were offered that way. And I'm interested if any of the other panelists have thoughts on that.
Yeah, I'll just step in to emphasize a few of the things that Sarah said. In particular, I can absolutely attest to the reality that these families have very high levels of mistrust with the government. They're very fearful, and with really good reason, right? So I think it was something that we really were made very aware of as we were implementing the task force and looking at how to implement the settlement. And I would say that, again, as Sarah mentioned, there are restrictions in terms of conflicts of interest, right, for the government to be providing some of these services directly, which is why they were very carefully laid out through other programs and in order to fall very clearly within what was permissible by law. And they're described that way in the settlement for very specific reasons.
Can someone talk about why legal services are necessary in this settlement? Why did the government agree to provide legal services for these families?
I'm going to jump in and start, but I want other people to continue. But I will set the stage a little bit by saying when the settlement was being discussed, there's a lot that goes into making sure that what the government's committing to is something that they're able to do, right? And so you'll note that the settlement does not provide blanket relief for all separated families, which is something that I think a lot of people would have liked and the ACLU would have liked. It would have been an easier way to address the situation. But there was a lot of care taken to make sure that everything was in compliance with existing laws and permissions. And so because of that, there is a sort of a patchwork structure of what the families are entitled to through the settlement. A lot of it is that they're entitled to access to certain options, right? So they're given access to apply for asylum because they were denied full ability to do that the first time that they arrived. And so because of that, it can be very confusing for families, and it involves a lot of many legal steps. Including establishing themselves as a member of the class to begin with, and establishing some initial process before they can even begin to consider asylum. And then I'll just add, and my colleagues here can speak more to this, but the asylum process itself is very complicated, right? It is not an easy process to understand. And in fact, there's a lot of decisions that the families need to make before they decide that they even want to take that option and use that option. And in order to both be ethically responsible in submitting those applications, and to the fulfilling all of the obligations to an individual who is going through this process who's already been traumatized, it really takes some consultation with an attorney and support from legal experts in order to submit the application. But I'll pause there because I'm sure my colleagues can say a lot more about it.
Maybe this is a good question for Danielle to follow up to give us some color on just that navigating that complexity as a provider.
Sure. Even something that maybe to immigration attorney seems very straightforward, like a re-parole application, submitting an application for an employment authorization document, a work permit. To someone who doesn't speak English, it is very challenging. Also, just even attorneys, sometimes if you don't fill out the form exactly the right way, USCIS could reject it and send it back. So just the basics of filling out a form, compiling a filing that is acceptable to USCIS, including the necessary supporting documentation, including a statement, again, in English that's signed, that is very hard for someone to do without an attorney. And that is, and I'm just describing one of the more straightforward applications, let alone if they're trying to file something with the immigration court that would require them to reach out to the attorneys, the government attorneys, again, by English, via email, to submit draft motions, get them signed and coordinate that whole process. And then the act of filing in court, making sure that you've served your copy on the opposing counsel. All of it is very hard to do without an attorney, let alone the complexities of asylum. And so that's been a huge challenge for us as in that, because we're limited in what we can do for class members. We cannot represent them, but so there's a lot of discussion about like, what is your fear of return and what might that look like going forward without an attorney? So it's, I don't want to say it's impossible for people to do without attorneys because they can, but it is very hard for most people.
Well, I mean, even in your example, someone who doesn't speak English, but then you add maybe someone who's young, a child, or has been traumatized by the same government that then now they're seeking relief from. That's an added level of difficulty. Thank you so much, Danielle. I'm going to turn now to a question from Mark Betancourt from the California newsroom. He's asking, are there backup sources of funding to keep this program afloat, even temporarily? I'd like to see, Kelly, if you could answer, and then maybe Sarah.
I'll just chime in to say No, is the easy answer there. For a little more context, here at the Young Center, we serve as the federally appointed best interest representative for separated and unaccompanied children. And sometimes that work includes trying to ensure that the kids that we're working with have access to legal counsel, trying to make those connections. And it is harder than ever to ensure children's connection to legal representation. Immigration legal services are being taxed at unprecedented levels right now, at the same time that federal funding for some of this work is disappearing. You heard Sarah talk about the termination of legal services for unaccompanied children, the termination of the Immigration Court Help Desk program. These terminations have caused a number of legal aid organizations to lay off significant numbers of attorneys and paralegals doing this critical, sometimes life-saving work at a time when the need is greater than ever. So there is no Band-Aid here. There is no short-term solution if these services are not continued.
Yeah, I'll agree with that. And I'm just going to say my name again because I know my last name is hard to pronounce. So first name Sarah, last name Van Hofwegen. But yes, the answer is no. There is no backup source of funding to continue to run this program. It just doesn't exist. In fact, the legal service providers who run this program, a lot of them are already being forced to lay off staff because of all of the other cuts to other programs. So it's not like they have money to float that they can just reassign people to the program. And Acacia is in the same position as everybody else. And Kelly, I really appreciated what you said about connecting people to legal services, because I think something that we hear floated a lot is like, why can't pro bono attorneys just come in and volunteer their time to do this work? And the reality is that even if you have somebody who is interested in doing this work, these cases are so complicated and they need so much support and training that it's a full-time job of an experienced immigration attorney to try to place and mentor people on cases. I mean, as an attorney, I have friends and family all the time ask me for tax advice or advice with other legal issues, and I am not qualified at all to do any of that work. And if I were to take on a whole new thing, the amount of training and support I need would be enormous. So we just don't have the trained people able to do the work for free, and it feels really naive and then disingenuous when the government proposes this as a solution, because the infrastructure just isn't there. It's just not realistic to expect that from people. And we have all these expert attorneys who could do the work if we would give the funding that we promised to them under this agreement.
Thank you so much, Sarah and Kelly. We have a question from Ryan Mina with the LA Daily News. They're asking for clarification. By classless, do you mean all children separated from their families under Trump's first administration? That might be for you, Sarah.
Yeah, or Michelle, you can answer it too. I was going to get us started and then throw it over to you. It means people who are considered class members under the Miss L litigation, which includes a lot of people who are separated at the border, but not everybody. There are carve-outs of people who weren't considered class members. Some of them are criminal carve-outs, and then there's other carve-outs as well. So for example, before I came to Acacia and I was attorney, I represented a 4-year-old girl who had been separated from her mother at the border, and then her mother had been deported back to Mexico. She eventually chose to reunite with her mother in Mexico, but because her mother had a 25-year-old conviction related to domestic violence that her mother had been enduring, they're not considered class members, so they don't benefit from the settlement agreement. But I'll turn it over to Michelle to provide more information.
I think you covered it, Sarah. I would just say that there is a process for registering as a class member. And so there are many people who are potential class members that are on a list of cases that have been identified as possibly having been separated or having physically been separated, but that haven't gone through the registration process through which the DHS goes through the documents and confirms that that individual that is applying and that child or that parent and that child actually were separated and qualify under the terms of the settlement agreement. And I will also say that there are cases in which there's controversy in that and they can be appealed. So that's another area where the Acacia's legal services are sort of separate from that because they only kick in once somebody has gotten through that process. But there are cases in which people need support from the ACLU, or Together and Free has handled a lot of those cases where we help people sort of prove who they are and get admitted to the class in the first place.
Wonderful. Thank you so much. Last call for any questions from members of the press. And as we wait for those to populate, I just want to turn to anyone, any of our speakers for final thoughts.
I'll just say a few final things. I mean, one, as Sarah was explaining the process, and Kelly on how difficult it is to get pro bono attorneys or to fill in that gap of attorneys, I hope that others were struck by this as well. But what we're saying here is that these cases can be so complicated that even a trained attorney who is not specialized in immigration law needs mentorship and guidance in handling these cases. So to think that families are being expected to do this with no guidance is really kind of crazy. So again, it just really emphasizes how critical it is to have organizations working to help families go through that process. And that is why that was included in the settlement as one of the provisions that was recognized as something that would be needed. I also want to emphasize what's been said about the timing here. So even if the government is able to set something up to fill in and they have if they have a plan, we have not seen that yet, which is one of the reasons we're very concerned. But time is of the essence here. And it took quite a long time to get the Acacia program going and operational. We have, for many of these families, at least about 1,000 of them have a deadline of December to get this paperwork in. And so we really don't have time for delays in getting people these services. And then finally, I would just say that, we have a settlement agreement here and it has been operating. It is awful to think that we are here in the last stretch of this and are going to drop the ball, which really makes so many families who were able to reunify at risk of being separated again and of having their entire world torn apart all over again, which is one of the fears that they've had and one of the things that they will always fear, right? So having that as another potential outcome here is really tragic and something that we should really be thinking about how we want to, how much we want to do to prevent that as a nation. The steps are in place, the process has been created, and pulling out at this last minute will really be tragic for thousands of people.
Thank you. We have a final question from Rachel Uranga at the LA Times, asking just for some more detail about how many people are in the class. Do we have a number? And do we know how many have still not been reunited?
So all of those numbers, if you've ever heard me talk about this before, are very imperfect. So I can't give any. People might be able to give some. And the reason I can't give any today is because those numbers change every day. The members of the class are based on who registers. There's a potential group that is larger than who has registered. And I don't know how many people have registered since I have left. And then as far as how many left to be reunified, we know that there's, many potentially that have not received services. Some of those may be reunified. So we estimate that there's up to about 1,000 families that may not be reunified, that there's been no no contact with whatsoever since the separation that the government was aware of, at least as of a year ago. But again, the numbers are hard to target. What you can know is that, we had a list of almost 5,000 families that the government cited as potentially separated. And many, many, many of those, the majority, as you heard Sarah say, have not received the full services of Acacia to hear about what they're entitled to and what they might want to follow up on.
And Acacia was getting what we call the class member list, class member information from the Executive Office of Immigration Review. That list included class members and then their qualifying additional family members. There were more than 8,000 people on that list the last time we received it, and it's been a couple of months since we received a list.
Thank you. Thank you to all of our speakers. Before we close out, I'm going to turn to Zain Lakhani at the Women's Refugee Commission for some closing thoughts.
Thanks. I think just to round it out, just going back to the stories and the voices of the people who are impacted, and going back to, I think, what has become very, very clear throughout this entire conversation, that this is not something that is happening to, or something that happened to families. It is a continuing and ongoing process. The very violent and visceral reaction of the public to family separation at the moment that it occurred, or at the time that it was happening, I think was so extreme. And then we don't necessarily realize how much it continues to live with people, the very real harm and the pain of ongoing separation, and inability to reunify, inability to find safety, inability to find safety that they might be entitled to or eligible for, is just really crippling. And so just to close out, I think just hearing one more something again from the voice of a parent who was still separated from her child at the time that the interview was taken. And it's just very short, but I think just says so much. She says, "Not a day goes by without me thinking of my son, wondering what he is doing and where he is, if he's behaving himself now that he is bigger and growing up." And just for so many people who have, who are watching loved ones or themselves raise children, to imagine the immense pain and suffering of not knowing where your children are and not being able to be together with them. Just wanted to end with that.
Thank you so much. Thank you, everyone, for your participation. I know there's a question from David, a staff member from a nonprofit, in the chat about whether there are concerns that the government may separate families again. And I think the answer is yes. We're seeing rocket dockets of children. We're seeing the removal of bare minimum lifelines in terms of due process protections, legal orientations. Children are going to be made unaccompanied or separated.